Good morning, everyone. This is Larry Boggs. We're going to start our estate planning seminar here this morning. I think most everybody knows me, but I am president and founder of Boggs Company. With me today is Chris Logsdon. Chris and I have been kind of informal or former partners in financial planning, estate planning, probably for the last 5 or 6 years. Chris is exclusive to financial estate planning, trust planning. He does not do divorce and other kind of legal things. Wrong guy to talk to. Today, he's going to highlight talking about wills, power of attorneys, medical power of attorneys. We're going to get into trust, whether that's revocable, irrevocable, spendthrift, special needs. And I'd like everybody to hold questions to the end. And it may be easier to direct all those to either Larry or one of my team members at the end. With that, I'm going to turn this over to Chris, and I'm going to be interfering with Chris a little bit, but it's pretty much going to be in his court. Thank you, everyone.
Thank you, Larry, and good morning, everyone. Truly a pleasure to be here speaking with you generally about estate planning. And this morning is really going to be just that, quite general, and a survey course to talk about estate planning. You know, one of the tricky aspects of estate planning is how individualized it typically is and how individualized it needs to be. A benefit of working with a great financial advisor like Larry is he knows you. He understands your family, your asset profile, your needs, and does a good job of working with someone like me, an attorney and estate planner who meets you in maybe only a couple of meetings, right? So sometimes I have to learn all about someone in just an hour. How then do I formulate an accurate and inclusive estate plan? Well, if I can rely on a partner like Larry, you're ultimately going to have a much better product. The other reason why estate planning in a discussion like this needs to be so generalized is I understand we have clients from several different jurisdictions. And while there are certain federal laws and federal taxes that pertain to all jurisdictions in our country, estate law is very much a state creature. So the laws of Maryland compared to the Commonwealth of Pennsylvania, compared to the state of New Jersey, et cetera, down the line, you're going to see some commonalities. That's where we're going to try to focus today, but you're also going to see some differences. So Brian, if we want to go to the next slide here. Thank you so much. So a couple of things we're going to be talking about today. We're going to focus primarily on the major types of documents, why they're important, and what your considerations should be. So what you should know about, right? One of the biggest questions, or I guess one of the most frequent subjective questions, is a living trust. What is a trust? Do I need a trust? What does a trustee do? So we're going to try to pay particular attention to that. Now, I'll say I'm utilizing a PowerPoint today that was created by a financial advisor here at Boggs Wealth, utilized in prior presentations. I think it's a good and it's a conducive way to guide our discussion. But of course, coming at this from the angle of an estate planner, I'll have my own spin on the content. Brian, if we want to, thank you so much. So more or less, what are we doing with estate planning? The way I like to look at it is we're taking what you own and we're saying, how is it going to get from point A, as I own it at time of death, to point B, that is where we want it to go, to whom, when, how. There are certain commonalities that we see in every estate plan, certain priorities that everyone has. They want efficiency. They want their assets to move promptly without sitting in some estate or some probate process at the courthouse for months on end. They also want their assets to move precisely. So they don't want this asset going there and that asset going here, at least not unless that's their intention. A good estate plan is going to look at these considerations and say, asset by asset, is this asset set up in such a manner that it's going to move efficiently, cleanly, in a protective manner? And that's so important. I think oftentimes people go to see a lawyer They get a will. The will says half of my estate to one kid, half of my estate to another kid, and they walk out of the office feeling like they're fully planned, but they're not. Estate planning needs to be an asset by asset consideration. What's going on at the bank? What's going on with my investment or retirement account? What's going on with my life insurance? Here we're thinking about beneficiaries first. And you'll see that at the second bullet point, right? So as we consider what those most important items are, we consider, are these most important items, right? Are these considerations actually going to result in what we want? Because if the will says all to this person and the beneficiary says all to that person, two different things are going to happen. So how do we avoid that? And we'll keep going, Brian, when you're ready. So 6 important things to know about estate planning. We're going to walk through these one by one. So be aware of probate. What is probate? It is the legal process for moving your assets at death if the asset has no other way of moving, right? An asset's got a beneficiary, an asset's got a joint owner. It's probably not going to go through probate. It has its own way of moving to the joint owner automatically, to the beneficiary automatically. Probate is when we have an asset that's in an estate. And so then we consider, okay, how do we move it now? That's the system, blessed by the courthouse of opening an estate, inventorying assets, and doling them out. Second, creating a will, right? So when we land in probate, how do we make sure that the state isn't going to decide what happens to your assets? A will is the instruction manual for probate. Who's in charge of the probate process? Where do my probated assets go? Okay. 3, decide on the beneficiaries of your assets. As we discussed just a minute ago, beneficiaries will control an asset. A beneficiary is a contract between you and the institution that holds your money. You name a beneficiary, what are you doing? You and the institution are agreeing in a legally binding way. If I die, here's who you're going to give this money to. But remember that a beneficiary is a straight shot. Money goes to the beneficiary or to the beneficiaries if there's more than one. That's simple. 4, consider a revocable trust. What if it can't be that simple? We want to stay out of probate, right? We don't want to have to go through the courthouse to transfer the asset, but we also don't want to just name a beneficiary, right? I've got a 15-year-old grandkid. I've got a 30-year-old son who's not great with money. What do? Consider a trust. It doesn't rely on probate to move the asset, but it has more specificity than a beneficiary. More on that soon. A power of attorney. We'll dig into this more. What if I lose capacity? I'm still alive, so my will doesn't matter yet. My trust isn't kicking in, so to speak. It's not doling out assets. What do I do if I've lost capacity? Well, that's the problem. You can't do anything. So your family is going to need to make sure they have authority to act for you. If not your family, a trusted individual. A power of attorney is going to let them act for you without having to go seek what's called guardianship in some states, what's called conservatorship in other states. Finally, having the talk with your family. So important. It's so important. There are certain instances where you know your estate is going to be sticky. And you might not want to have a talk with your heirs because, golly, it might cause issues, might cause friction. They object to what you're doing. But more often than not, it's going to make a whole lot of sense to sit down as a group and to say, here's what I've done. Here's how I've planned. And here are the folks you need to speak to. We'll keep going, Brian, when you're ready. So circling back in greater depth, probate. It's a great summation. It's the process the court uses to settle a deceased person's estate. So if I own a house, I'm the only name on my deed. Or let's say, my wife is on the deed. We die at the same time. She dies before me. Everyone on the deed is deceased. Who owns the house? My estate owns the house. There's no one else on the deed. There's no trust. There's no other way to transfer. It goes to my estate. How do we get it out of there? We go to the courthouse. In Maryland, we call it the Register of Wills. Many jurisdictions do. In other jurisdictions, it's broadly the probate clerk, a function of the county commission. Well, that process is going to say, open an estate, give notice to creditors and claimants by posting in the newspaper, inventory what was in the decedent's sole name, and then submit an accounting asking the court permission to distribute. We'll talk more about a will soon, but if you have a will, it'll say what happens. If you don't have a will, state law is going to say what happens. We'll go on to the next slide when you're ready, Brian. Thank you. So, what is the importance of creating a will? Well, here in Maryland, we have a pretty, I think, nicely bifurcated system. Administrative probate, judicial probate. What's true for both? It's in the name. You're in probate. The asset was in your sole name. Whoop, you passed away. Now it's in your estate. Why would we be in judicial probate? Because we don't have a will. So the judges of what we call the orphans court, which is our probate court, they're in charge. And they're going to say, all right, the law sets forth a list of priorities for who can be the executor. We'll decide who gets appointed based on that. The law sets forth who gets the estate. Usually we say to my spouse. If I have kids from before the marriage, part to my spouse and part to my kids. If we're both gone, to my kids, or it might go out further and further and further to siblings, to nieces, to nephews. Common misconception. People think if I don't have a will, the state's going to take my estate. No, probably not. Probably not. Not unless they can't find a relative or heir. But they are going to move out on these, what's called the degrees of consanguinity, right? Spouse, kids, grandkids, parents, grandparents, siblings, nieces, nephews, cousins. It goes all the way out, right? It's messy. Judicial probate is messy. You need the judges to bless everything, and a lot of the decisions are made for you by state law. Administrative probate is better. Means you have a will. The will's going to say who's in charge. The will's going to say to whom the estate goes. Now, I want to make this clear. Even if you take steps to avoid probate, even if you sit and say, I've got a beneficiary on everything. My lawyer gave me a living trust and everything's been transferred to it. You still need a will. Why? Because if an asset has no other way of moving, it's going to end up in your estate. It's going to end up in probate. So what about that reimbursement check your family got after you died that they weren't expecting? What about that inheritance you got from your brother that said in his document, all to my sibling, and never anticipated my sibling might die before him? That's going to land in probate. And a will's going to make sure it works in synchrony with your other wishes. We'll keep going. Thanks, Brian. Decide on beneficiaries. This is so, so important. Go to the bank. Talk to Larry. Talk to any other financial houses where you have investments or retirements. And make sure you are aware of whether you have a beneficiary. They might call it a transfer on death. They might call it a payable on death. It's all the same thing. It's a person tagged on the account who will get the account if you die outright. Okay? There's good and there's bad. If you're someone saying, look, I got 2 kids, they get everything 50-50, they get it outright. Great. Make sure they're the beneficiaries here with Larry. But make sure you go to the bank too. Make sure that for your checking, savings, CDs, or the like, they are your transfer or payable on death beneficiary. Because people will create a beneficiary on their IRA, they'll say, great, I'm covered. What about your checking? What about your savings? Name a transfer or payable on death beneficiary there too. But make sure also that your family knows where beneficiaries are listed. I've seen it happen before. Someone comes into my office, mom passed away, right? Where now does the account go? Well, if we know where the account is, we know what it is, we know who the beneficiary is, give them a death certificate, go transfer the funds. But what if mom was at a bank and had some account that she didn't tell the kids about? The kids aren't going to know. Maybe the bank will send notices. Hey, your account is dormant. Has something happened? And hopefully the kids will get that in the mail. But it's so important to have somewhere generally accessible in the event of death, a list of where your accounts are and who is named as beneficiary. We'll keep going. Thank you. Always, always, always up to date. Famous case here in Maryland, right? Man had wife named as beneficiary on his life insurance. They divorced. He remarried. He had 2 kids in his very happy second marriage. They had a great family. He set up a will and a trust, left it all to his second wife. If they're both gone, all to their kids. He never updated the beneficiary on his life insurance. Sorry, the wife was unsuccessful. A beneficiary is a direct route for the money to move to the individuals you named. So if an individual passes away, if an individual is divorced, if an individual goes into a nursing home, right? You don't want your sister named as the beneficiary on your brokerage account. You die, she has dementia, she's in a nursing home. Let's say she's on medical assistance, a sub-program of Medicaid. You just gave the state all your money. So it's so important that on at least an annual basis, if not a biannual basis, you're checking the beneficiaries on all accounts to make sure they're up to date. Make it easy on yourself. Keep a list. Check your list at home twice a year. Okay. And yes, that's an excellent. Other assets, cars, boats, other sentimental items. It's hard to name a beneficiary on a car or a boat, right? You don't want to name someone as a joint owner. That can mess you up from an insurance standpoint. Certain jurisdictions will let you name a beneficiary on a vehicle. It's important that if you go to the MVA, as we call it, or the DMV in other states, that you ask them at the time that you renew your tags or what have you, can I name a beneficiary on my title? Different states and jurisdictions have different rules. For example, here in Maryland, you can have 2 names on a title. One person dies, the other automatically gets the car. You can do a transfer on death in Maryland, but if you got 2 names on the title, they won't let you do a TOD. Mom and dad are both alive, both on the title, survivorship. Mom and dad are both alive, only dad's on the title. Tag mom as the beneficiary. The MVA here in Maryland will cost you $40 to do that. Again, most other jurisdictions will let you do that too. Sentimental items, valuables, well, you can set forth a will that says who gets what. It's a problem though. Items walk. If you've got an item, a piece of jewelry, an antique, and you want to be absolutely sure that a certain individual gets it, give it to them. That's my best advice. Give it to them. I can't tell you how often I have seen nasty, horrible, expensive litigation fighting over, say, a ring that no one can find. Okay? That happens. So if it's really important to you, give it to them. Otherwise, there's a better way of leaving items than a will, which we'll get to here in a moment. Thank you. Taxes are a question that we get a lot. This is really tricky. And I'm going to tell you first and foremost, talk to your accountant, talk to Larry. Larry's a wealth of knowledge when it comes to the tax treatment on your assets. Larry and your accountant working together, they'll do a great job by you. We think of 4 taxes in my field: income tax, capital gains tax, inheritance tax, estate tax. Those are the 4 taxes we worry about. Income tax, when do you worry about that in estate planning? When you have a retirement asset that is tax deferred, sometimes called qualified, 401k, IRA. Someone's got to pay the tax man eventually. If you're 73 or older, you're already required to take a minimum distribution and pay taxes. You leave that account to your spouse, they get it without paying any, I guess I'll say, additional tax than what's required through your minimum distributions. But your kids, they got 10 years to draw out a retirement account. And over those 10 years, who's paying that tax? They are, together with the rest of their income. If you ever do a trust, make sure you ask the attorney, how is this going to impact my retirement account taxation? The attorney should come up with a specific plan for treating retirement accounts. Okay. Now, additional taxes, capital gains tax. We want to be careful about how your estate plan is set up. Why? Because we want you to get what's called a step up in the tax basis. You bought Apple stock for $1 a share back in the 90s. Good for you. It's now worth way more. But you know, if you sell that and you don't have a good loss to offset it, you're going to pay a gains tax on that whole difference. If your estate plan is set up the right way, without, I guess I'll say, undue restriction, your beneficiaries will get a step up in basis. They won't pay the difference between what it's worth today and what it was worth when you bought it. They'll pay the difference between what it's worth when they sell it and what it was worth the day you die. Cuts out a whole bunch of tax. But if you gift the asset to your kid, that stock or that real estate, if you put the asset in an irrevocable trust, a special kind of trust that you can't change, it's going to mess up that step up. So again, this isn't a full tax tutorial. Ask your lawyer, is this going to mess up my retirement account taxes? Is this going to mess up me getting a step up in the tax basis for capital gains? Finally, there's estate tax and inheritance tax. Depends on the jurisdiction you're in, right? Pennsylvania, no estate tax, but they've got an inheritance tax. Other states, they've got an estate tax, but no inheritance tax. Some states have neither. West Virginia, the Carolinas, etc. And Maryland, lucky you, to those of you who live here with Larry and I in Maryland, we're the only state in the country with both estate and inheritance tax. What are they? Estate tax is how much do you leave behind. You can leave up to a certain amount. In Maryland, 5 million individual, 10 million married couple. Federal government, 15 million individual, 30 million married couple. Anything above that, you're getting taxed. You need to come up with a plan with a lawyer, with your advisor, with your accountant. Inheritance tax. Inheritance tax isn't how much you leave behind, it's who you leave it to. For example, here in Maryland, there is no inheritance tax on anything you leave to your spouse, your parent, your kid, your grandkid, your sibling. But if you leave it to a niece, a nephew, an aunt, an uncle, a cousin, a friend, they're going to pay 10% on every dollar. So I don't think I'm related to anyone on this call. If you're a Maryland resident, you leave me behind $100, I got to pay the comptroller $10. Estate tax? That's not a problem. Not as long as you're below 10 million and you're married, or 5 million and you're an individual. Again, I'm throwing a lot at you. The notion here is caption headers, so you know what to deal with when you're planning. We'll go on to the next slide, Brian. Consider creating a trust. Why? Well, maybe you don't need a trust. Again, I got 2 great kids. They get everything 50-50. They get it outright. Awesome. Maybe what we do is we name them as beneficiary on all of your accounts. We might take a look at your deed, see if there is some way through, say, a life estate or a transfer at death deed that we can transfer to them. It's going to depend on what state you live in, what we call it, and how it works. But there are ways of transferring title without going through probate. But for a lot of people, it's not that simple. We have an heir who can't be given money. They're not good with money, or they have a spouse who causes issues, or they're a minor, or maybe we've just got so much in our asset profile, it's not feasible to do a litany of deeds and beneficiaries. A trust is a coordinated way of moving all assets outside of the court system. For example, let's say I've got a trust. I deed my house into the name of my trust. I name my trust as the title owner or beneficiary at the bank and here with Larry. I list my trust as beneficiary on my life insurance. All those assets are going to move to my trust then without having to go through probate. So when I die, my trustee, the individual in charge of the trust, they step in. They say what all is in this trust, and they look at what the trust tells them to do in terms of distribution. Remember before I said a beneficiary is a contract between you and an institution. If you die, they'll give the beneficiary the money. Well, a trust is a contract between you and the trustee. If I die, the assets in this trust, you trustee, you're going to do with those assets what the trust tells you to do. You shouldn't need the Register of Wills or the probate clerk in order to accommodate all that. Why do I say shouldn't? Well, things can go wrong, right? There can be an issue with the document. There can be an asset that you miss, that you don't direct straight to your trust, that now lands in your probated estate. And so you got to be really careful. Did my lawyer write me a trust, charge me a ton of money, have me sign it and say good luck? Or did my lawyer talk to me about, here's what you need to list on your accounts. Here's a deed for your house, right? That's a lawyer who's looking out for you, who's making sure your trust is going to allow all this to move without great complication. It's an in-depth, complicated process. Do not be the 95-year-old who is just starting to consider writing a trust. It takes time. It takes time to get in with a lawyer, and it takes time to formulate your intentions. It might take a couple of meetings to parse through everything and figure it all out. But with time and organization, you're going to create a thorough and proper estate plan when you create a trust. We'll keep going, Brian. Thank you. Power of attorney. Why? Why do I need a power of attorney if I'm fully competent? Well, because if you wait until you're not competent, it's too late. Famous, well-publicized case from the last year or two, Jay Leno. Sadly, Jay Leno's wife has a progressive form of dementia, and she reached the point where she could no longer act for herself. So in California, he had to file for what they call conservatorship, what other states call custodianship or guardianship, which says, look, we've got an adult. They can't act for themselves anymore, but they never appointed someone else to act for them. What do? We need now to go to the court. We need to tell the court the individual is incompetent. We need to report to the court what the individual owns. It's a public process. It's a messy process. It's an awful process. A power of attorney is a piece of paper that says if I cannot act for myself, and you can require that a physician certifies You cannot act for yourself. Then here's who can act for me instead. Do you need a power of attorney if you're only in your 30s, 40s, 50s? Yes, you do. Every adult needs a power of attorney. Do you need a power of attorney if you're married and most of your assets are joint? Yes, you do, because your spouse is going to have a hard time selling the house, filing the taxes, dealing with your retirement. Everyone needs a power of attorney. It's going to save so much time, so much money, and so much, I'll say, embarrassment in the judicial system to have in place. We'll keep going. Thank you. A durable power of attorney speaks to one half of the whole: financial and legal transactions. So, what does a durable power of attorney mean? Well, let's make it tricky, right? My sister and brother-in-law went to Europe a few years back. They were going to be in Europe for a little while. It was a great trip for them, but they wanted to make sure that if something arose at the house, there was someone who could sign a contract to stop the leak or fix the caved-in roof or what have you. They created a limited power of attorney. It gave a member of our family the authority to act on their behalf only for the span of time when they were gone. It's not a durable power of attorney. What's a durable power of attorney? It's one that you sign and it sticks around. In all likelihood, it's the one you're going to want. That's why we call it durable. You sign it, you say someone else can act, it remains in force even if you lose capacity. For most people, it's only in force if you lose capacity and not until then. So you can have a power of attorney that's immediately effective. Hey, the person I name, even if I'm competent, I'm just laid up with a broken ankle at home. Go in and see Larry, sign documents for me. Or springing. Springing says, it's not enough to take in the document and act for me. You need a physician certification that I've lost capacity. It's all based on your comfort level. Larry and I had a client with a young son. Named the young son because the individual really didn't have another member of the family she trusted to name. But he's young, so let's only let him act if it's necessary. She's still in good health. We're going to require a doctor to sign. But I'm 87. I got a kid I trust completely who's going to be in charge of my assets. Maybe I'll make it immediately effective. That way, if I'm in so-so condition, they can go ahead and step in and start acting for me. What's your position in life? Who are you naming? What is the level of trust? We'll go on to the next slide, Brian. Healthcare power of attorney. Two halves of a whole here, right? Financial and legal, medical decision making. Do you need a medical power of attorney if you got a spouse and kids you trust? Won't the doctor just step into the waiting room and talk to next of kin? Maybe. But for those of you who will remember a case from about, 20, 25 years ago now, Terry Schiavo. No medical power of attorney. Husband felt one way. Parents felt another way. That never would have happened, that big legal battle between the husband and the parents, if there was a proper legal document in place saying who was in charge of medical decision making. What if you got 3 kids? One is sentimental, 2 are, let's say, logical. You're in rough shape. Your sentimental kid doesn't want you taken off life support. You need a medical power of attorney to say who's in charge, or the third king can go to the courthouse and cause a whole lot of trouble, I'll say, delay, expense. So a medical power of attorney is going to do 2 things. It's going to say who's in charge, and it's usually going to contain a living will. The living will is going to say if 2 doctors or however many doctors it requires say that there is no hope of my recovery and I can no longer act for myself and make decisions, then here is what I would wish to have happen. Keep me comfortable. Let me pass naturally. Let me pass, but give me nutrition or hydration by tube. Try to extend my life as long as you can. It's a personal decision for you to make. And you can then say, follow it as written, or you can say, the person I named as my medical agent has the final say. It's going to depend on your comfort level. It's going to depend on the individual you name. My medical power of attorney says that if two doctors certify there is no reasonable medical expectation I'll recover through intervention, and I'm permanently incapacitated, I said, keep me comfortable, let me pass naturally, and once two doctors certify, follow it as written. Because the folks I've named, I don't know how they would handle that decision. Other people, just as many, feel quite comfortable saying no. I'll give them the final say. Next slide. Thank you. Have the talk. All of these things we're talking about, these decisions you need to make. It's so important that you discuss them with the individual you're speaking to or you're going to name, right? How do I know that the members of my family I would name to make medical decisions for me really don't want that final say? They told me. I asked them. They said, look, we really don't want to be in that position. Once doctors have certified, we'd prefer to follow the doctors. I said, okay, I agree. So we're going to say follow it as written. Okay. But this is true for everything. When it comes to deciding who's going to administer assets when you die, when it comes to whether or not you feel your kid can manage the money that you leave for them, when it comes to who's going to make financial and legal decisions if you lose capacity, and again, those medical decisions, have the conversation. Not everyone can do it. Not everyone can, either because it's too difficult to discuss or they're worried it'll create discord in your family. Okay, well, then maybe you just need to make the best decisions you can with the information available. But it's always better when the family knows what's going to happen when you die, because there is less likelihood of a fight then, the kids knowing what was mom and dad's wish. And I've done that many times where we create an estate plan and then the client says, Chris, we need one more meeting. And at this one, we're going to have the kids there. Okay. And we're going to talk about what's going to happen. Living trusts. This we're going to spend some extra time on, right? A deeper dive. Why do a living trust? Well, we want to talk about two things, right? Probate avoidance, flexibility and control. That's why we do a trust. Okay. Probate avoidance. Let's revisit what I said before. If I deed my house into the name of my trust says what happens to my house or the sale proceeds therefrom when I die. I do not need the Register of Wills or a will or probate to say what happens to my house. I do not need the general public to know what my house is worth or what my wishes were. And I do not need my executor sitting and waiting on legal processes to unfold. I can create a trust. I can put my asset into that trust, and my trust can say what happens privately, efficiently, and without susceptibility to the legal process or claimants and creditors. That's one reason to have the trust. Flexibility and control. Let's talk about flexibility. If you have a revocable living trust, a revocable, not an irrevocable, a revocable living trust, you can change the document. Happens all the time. Larry and I had an awesome set of clients. Larry's been working with them for decades. I've been with them for years now. Wrote them a trust right before COVID, maybe a month before the lockdown. Now they're saying, Chris, it's been about 6 years. Let's blow the dust off. Let's make sure all of this works the way we want. Let's make sure the trustee is still someone we would want it to be. Let's make sure the shares are still going to be divvied out the way we want. That is a very intelligent couple because they're revisiting their document every couple years to see if the laws have changed, to see if their wishes have changed. And we updated their trust. It's that easy. It's revocable, meaning you can get rid of it. It's amendable, meaning you can change what the document says. But it gives you control. For me, let's say, for example, I don't have kids, because I don't. but I've got a nephew. He's a year and a half. I want to leave him part of my estate, but he's a year and a half. The beauty of a trust is where I cannot name a year and a half kid as my beneficiary, I can name a trust. And the trust can say, catch the money if I die. The trustee can advance money for him if he needs it for his health, his education, or for some other good cause. Otherwise, my trust says, you get it when you're 30. Other people might do something different. They might say, you get half at 27 and you get half at 32. You get a third at 30, you get a third at 40, and you get a third at 50. Larry and I had a client say the money is held in safekeeping. You get a percentage every year. Let's say 5% of what your share is worth. You're going to get that every year. Okay, 5%, probably just going to be the income. Draw that, you get it quarterly. All the while, slow growth if the account grows more than 5% a year. And then you'll get it at 55. So what did mom and dad just do for you? They've made sure the trustee can advance money if you need it. They've given you a recurring annual benefit paid out quarterly by percentage. And they've also created a nest egg for you when you retire. They didn't give you a lump sum, but they've set you up for all your needs. And finally, we'll talk about what happens if you pass away, you being the beneficiary. Where then does the money go? The trust can provide all that. We'll keep going, Brian, when you're ready. Thanks very much. So what is a trust? How does it work? Think of a trust this way. The trust is like a legal person who you create on paper, okay? I take my house, I deed it to my trust. I've given my house to the trust I created. Now, the trust I created says Chris has still got all the power, right? He can change what the trust says. He can get rid of the trust. He can sell the house. He can buy a property elsewhere and put it into the trust. And isn't that great if you've got a house in 3 different jurisdictions? 3 different estates in 3 jurisdictions? That doesn't sound very nice. Create one trust and have a lawyer in each jurisdiction deed the property in their jurisdiction to it. Great. All moves at one under your trust. That's because the trust is like its own legal person. You die, the trust doesn't die. The trust lives on. And the trust then does what you told it to do. But it's pivotal that you put your assets into the trust. Don't be the client. And I'll tell you, it's never your fault. It's the lawyer's fault. Don't be the client who goes to the lawyer and pays a couple $1,000 for a trust and doesn't deed the house into it, doesn't name the trust as beneficiary. I said this already, but it's so important. Put the assets into the trust or name the trust as the beneficiary. Create the mechanism for the asset to be in the trust or to move to the trust without probate. But if you're someone who, say, owns a business and you got this great fancy trust and the business interest is still sitting in your name, you've wasted your money on the trust. Transfer the business interest into the trust. I got 2 LLCs. I've transferred them both into the name of my trust. My trust is the member of my LLCs. It makes no difference for my taxes while I'm living. It makes no difference for my control of my business. It makes no difference for my ability to sell the business. What it does make a difference, my business won't go through probate. My trustee can act like that if I pass away. Strike while the iron's hot, and my business is still valuable. We'll keep going, Brian. Duties of a living trust executor or trustee. Thank you. So, what's going to happen if an individual loses capacity? Well, again, we've got a financial power of attorney hopefully in place who can act on behalf of their parent who has lost capacity. But what about a trust? Can a trust help us if you lose capacity? It's going to depend, right? So if you lose capacity, you resign, or what have you, the successor trustee steps in. They now control the trust. Someone you named in the trust to step in if you can't. What do they have control over? Well, if you've got an account and you've named your trust as beneficiary, that was smart. That was fine. Your account will go straight to your trust if you die, but technically that account is still in your name. So who's going to control it? Your financial power of attorney. But what if your advisor says, yeah, but you've got a brokerage, right? Larry says, let's retitle the trust into the brokerage. That way, if you die, it's already in there. But why else might you be doing that? Because it's already then in your trust, right? If an account is titled in your trust, it's under the jurisdiction of your trust. And your trust is probably going to say, if you lose capacity, the trustee is to use the money for your benefit. It's the trustee in charge of that money, okay? So they're going to act on behalf of your trust if you lose capacity. What then I think makes good sense? Usually you're going to want to name the same person or people on the trust and the power of attorney. The assets in the name of the trust, trustee is going to administer that. Power of attorney, the assets in your sole name, okay? Having the same person, they're controlling all of it. That's not always the case, though. Sometimes people say, yeah, but Chris, that doesn't work for the trustee. Because if I die, I don't want one of my kids administering for the others. Name an institution, name a bank, name some entity, a professional trust company. That's fine. Just be aware that if you lose capacity, that company will control assets currently titled in the name of your trust, and your financial power of attorney will control assets in your sole name. None of that's a bad thing. You just got to make sure you're aware of it and your lawyer is doing it intentionally as part of the planning. We'll keep going. Death of your surviving parent. What do you do if an individual passes away? Well, my guess is a lot of you are attending this not because you're worried about what happens if someone else passes away. Now, that might be the case, but you're probably worried about what happens if you pass away. So I'm going to flip this slide around. Make sure that you have an index of assets, as we said before. Your kids don't know what they don't know. And I've seen it before where we have to write a letter that we mail out to all the local banks, financial advisors, etc. Hey, if Joe had an account at your institution, we need you to send an updated account summary to the address of record. Why do we do that? Because we don't know where the accounts are. And it may not be on the face of your legal documents. Your trust, your will might not list out everything that falls under their jurisdiction. We definitely don't know where your beneficiaries are. Keep an index. Ideally, your attorney will work through with you on creating an asset profile. And the attorney will have little notations because every now and then I get the call. Hey, Chris, mom died. Dad died. What do I do now? It sure is nice when I can say, well, mom had money with Larry Boggs. Mom had money at this particular bank. Mom had a life insurance policy with this company. And you probably know already where mom's house is. But didn't that make it easier for the kid that I could tell him? What would make it even easier? If you made the list, if you said what was where. That's going to make their life far simpler. If you're really batting 1,000, you'll also make a list of your recurring expenses. You lose capacity, right? Who pays the bills? What bills need to be paid? Have a list of what your recurring bills are. And make special note of the bills that need to be paid manually by check or online, and which are not just auto-debited. Make a list of your income sources. Be planned out. We'll keep going when you're ready. Thank you. Get help if you think you need it. I'm going to tell you right now, you need help. This is extremely complex. I know that you're all going to say, Logsdon, you got a vested interest in telling people this. I'm going to say it anyway. I don't like form books. I don't like online, LegalZoom, Rocket Lawyer, these commercials. Why pay a lawyer money when you can go for $200 and create a trust? It's a terrible idea. Now, should you be paying a lawyer $15,000 for some estate plan? No, you shouldn't. That's unreasonable. You should pay a lawyer a reasonable fee. But think of it this way. You're paying a couple $1,000 for a trust, deed work, a will, etc. You're paying maybe less than that for at least a power of attorney, a medical directive, and a will. Well, golly, would you think twice if the grandkids wanted to go down to Disney World and it costs you $8,000 for the week? Would you think twice if you're taking your July vacation to the beach and you're spending thousands of dollars for that? These are the most important documents you will ever sign. They dictate the disposition of your legal status and everything you've worked to build. Why is this the scenario where you're trying to save a buck? I have that tough conversation with clients all the time when they're on the fence about whether to work with a lawyer, whether to work with a financial advisor, whether to work with an accountant. Work with all three, but work with someone who's reasonable, someone who's thorough, someone who you trust, okay? Don't work with someone who, if they don't pass the sniff test, they're not worthy of your work. All right. We'll keep going. A final thought on taking care of your loved ones in order to taking care of your estate in order to take care of your loved ones. Don't leave them a mess. Even if there might be messy things to consider, clean up a portion of that mess by planning ahead. Don't be the individual who has a surgery scheduled next week and you're trying to get in with a lawyer. No, it's not that easy to get in with a lawyer, right? Make sure that you plan ahead and don't leave behind a mess for them. Larry and I had a wonderful client, brilliant client who was so successful, owned a lot of property, had a lot of money. And of course, Larry, as he always does, encouraged him to engage in planning, but he didn't. So in the last couple days of his life, he listed out a whole slew of beneficiaries, and he couldn't do much more than that in terms of legal planning. His executor had a real process on their hands. Now we helped him. We worked through it, and it worked out. It really did work out for them. But golly, if this client had planned ahead, had created a document, had conveyed assets into the name of that document, it would have been much less expensive. It would have been far faster. It would have been overall easier for the family by planning ahead and by being organized. So do that. Have the conversation. If you're all Larry clients, as I'd expect you to be, have the conversation with Larry. Have the conversation with folks who you trust. Go see a qualified estate planning attorney and figure it out. Now it's just fine print on the conversation. I want to turn things back to Larry really quickly for a conclusion before saying just this. Q&A, any questions, concerns, issues, have those conversations with us. I don't usually do a Q&A whenever we give a talk. Why? Because I don't want you to even accidentally disclose a highly confidential situation or asset. So that we don't run that risk, I'm just going to conclude, say it's wonderful talking to you all. I'm Larry.
Chris, thank you so much. You covered a lot of ground today. I think you gave everybody a good general idea about trust, about wills, about power of attorneys. I think you emphasized more than once the significance of taking the time to explore all your situations and make sure you do it. As far as some of the question and answers, my team is here. Direct any of them to me or to anybody else. Chris and I are in contact, not daily, but multiple times a week. So if you gives me something that I can't answer, I'll be happy to relay to Chris. And I want to thank everybody for taking the time today out of your busy schedule to participate, and have a good weekend coming up. Thank you, guys.